Good morning, everyone. Welcome to We Are the City's latest webinar. It's Women Know Your Employment Rights. I'm Georgina Calvert-Lee. I'm an employment and equality lawyer working at McAllister Olivares. We're a feminist law firm that's striving to make things fair for everyone across all sorts of walks of life. At work, of course, we're going to focus on that today, but also in the community, in the provision of goods and services, and in education. But today we're talking about work, so that will be my focus. And it's important for me to get out news about equality law because people don't know their rights. And we have pretty good equality laws in this country, but they're really only as good as the use that we put them to. And in order to put them to use, we have to recognize discrimination where there's discrimination, and we have to be able to frame that so that we can then do something with it to shape our workplace. And that's really important. I often get calls from people who are often very successful, really good at their jobs, intelligent women. And they call me because something just ain't right at work. And they can't quite put their finger on what that is, but they know that something is not right. And it takes a good deal of conversation sometimes to understand, for them to understand what's going on. I often quite quickly see indications of discrimination because there are recurrent themes that you see across workplaces. But people don't recognize it. They don't want to recognize it, partly because there is a stigma attached to being a victim of bullying or discrimination. It's a ridiculous stigma. You've done nothing wrong. The discrimination is about someone else abusing their power, trying to take control. And there's no reason to feel stigmatized if you're bearing the brunt of that. But people don't. They are very quick, especially women, are very quick to blame themselves at first, to think of all sorts of reasons for their difficulties at work rather than discrimination. And so let's think about discrimination and what that looks like. Now, occasionally, and not very often, but occasionally, it's quite clear cut. Well, I say not very often, actually, people who have felt it will not, may feel it more than once. For instance, there's a sort of pregnancy discrimination that often happens. Someone will report that notify their employer that they're pregnant. And lo and behold, even though the business is thriving and expanding, the next week they discover that they have been made redundant out of a pool of one, usually. That's a very clear-cut case of pregnancy discrimination. Other things may be unequal pay. That's fairly black and white if you can find out about it. But discrimination is not always like that. Most often it's this. I've put up a whole number of things, but it's discrimination by the infliction of a number of little wounds, hundreds of little wounds often, across a year or 2 years. And this is really difficult to identify because each individual instance may seem quite trivial. It's not really trivial, as we'll come on to discuss, but it seems trivial. And because of that, the person on the receiving end tends to dismiss it at first. And sometimes, you know, a one-off trivial event where you feel slighted, maybe nothing, it may not indicate a systemic discrimination. But if it continues and it repeats itself, then it's not good to talk it away, because what happens is people will internalize their sense of grievance, but internalize it in a way that they blame themselves for these things. And over time, that can cause both mental health difficulties, but it can also actually impact your performance, because if you're having sleepless nights, if you're becoming very anxious about how you behave because you think it's all about what you're doing, then it can impact your performance. And that makes you even more vulnerable to an employer or boss who wants to slight you anyway because you're a woman. So that's another form of discrimination, and it's often those sorts of more nuanced discrimination that is the sort of thing that takes some time to talk through with someone else and to frame, to understand as discrimination. So on this webinar, what I'd like to do is to give you back control. It's about taking back control, and I apologize for the Brexit nuance. That was not intentional. I'm talking about you taking back your control over your workplace so you can shape it to be a workplace that is friendly to you and to other women. And so what I'll be focusing on is discrimination. Now, that will obviously call for a discussion of the Equality Act, because the Equality Act is the main statute that describes and defines discrimination under the law. The Equality Act has three main forms of discrimination. There's discrimination itself, harassment, and victimisation, and I'll speak about each of those. But beyond the Equality Act, it's important to know about other key rights that you have, which are not strictly speaking discrimination, but they're very much aligned to it. So, for instance, the Employment Rights Act gives you various rights related to unfair dismissal. You know, they talk about fairness, but they're not necessarily fairness in terms of discrimination and being treated differently because you're a woman or because of your race or any of the other characteristics we'll talk about. The Employment Rights Act is also important for whistleblowing protection. And then it's important also to consider some other broader rights that you have, because it may be that the Equality Act and the Employment Rights Act can't help you because they have a very short time frame in which to be asserted. You actually have to bring claims under those acts within only 3 months of the event having happened. Now, given that once you've been discriminated against or blown the whistle and suffered a detriment, it's extremely painful. It takes a while to come to terms with that. For discrimination, you may not even recognize it. And you need to be able to file a claim with the Employment Tribunal, or in fact, ACAS, before you file with the Employment Tribunal, within only 3 months. And on top of that, you're meant to have exhausted your internal employer's grievance process before you file with the Employment Tribunal. Now, in my experience, even that, just the grievance process, can take a lot longer than 3 months. So inevitably, you're going to have to decide very quickly whether you're going to file a claim against your employer or not. Often the 3-month period has passed by the time people come to me. And in those circumstances, you won't necessarily have lost all of your rights, but we'll have to think of something else. And that something else may lie under the Protection from Harassment Act. That has a much longer time frame in which to bring a claim. There's also stress at work. So we'll talk about all of those things, but I will say at the outset, you have quite a lot of employment rights, and I'm not going to get into the nitty-gritty. This is very much an overview. And we could talk sort of all day and all night if we were going into vast detail about everything. But I hope that what I give you will give you at least the framework for discrimination and what that looks like. Before we launch into the acts themselves, let's just also give ourselves another incentive to do that if we need it. And by looking at the gender pay gap reporting, because I've just put up a number here, one of the numbers from 2020, the average gender pay gap for financial managers and directors is 32%. That's a pretty whopping pay gap. And if you look at the bonus figures, actually the gap in bonuses in the financial services sector is about 37%. So if you add them both together, you're getting to a very high pay gap, overall remuneration gap, if you're working in that sector. It's worth noting that the gender pay gap is not the same thing as an equal pay claim, but it's worth noting because if you work in an organization that has to report on their gender pay gap, and that would be a big organization, someone or some private or public organization employing 250 or more employees. If you're working in one of those organizations and there is this whopping great gender pay gap, it may indicate that there is unequal pay existing within the organization. But if I explain, first of all, what the gender pay gap reporting is looking at, you'll see where the difference lies. Gender pay gap reporting looks at the average hourly wage of a male employee compared to that of a female employee. And in getting to that average hourly wage, they're adding up the salaries from someone at the top earning the most, the CEO, down to someone, say, working in the mailroom or at a lower salary. And often the difference in the gender pay gap is because the senior roles tend to be occupied by men. And so that brings up the average. Now, that's another question in itself. Why is that the case? And that, I guess, will be the subject of another talk. But in any event, the gender pay gap, I put that in here really just to motivate us to look, to reconfirm, as if we needed a reconfirmation, that discrimination is sort of alive and kicking in the workplace. Now, what about equal pay? What if you do think, well, whether or not your employer is a large organization or not, and whether they report gender pay gap or not, you may think, I'm not being paid the same as my male colleague who's in the same role. And if that's the case, then you may well have an equal pay claim. For equal pay, it very much depends on finding a comparator, which is a technical term for someone, a male employee who's working in the same role as you. That would be the sort of perfect comparator. But often you don't have someone who's working in exactly the same role. So in those situations, you might want to look at work that's quite different, but you think is of equal value to the organization. Now, a good example of that is the ASDA equal pay claim that has been going through the courts for some years now. And they recently had a decision on their argument that women who were employed to work on the tills in the stores were providing work of equal value to their male, largely male, perhaps all completely male colleagues who were working in the distribution centres. And they looked at things like the stresses occasioned by the type of work you're doing. You know, sitting on the shop floor, you have to interact with customers. And that creates a level of stress, maturity, skills, communication skills that are required. In the distribution centres, there are other skills that are required. But the female claimants, the women till workers in that claim, were saying, but our job is every bit as demanding as working in a distribution centre. I mean, I would think it's probably more demanding, but it's at least as good as, and there should be at least as much value is given to the organisation, and it should be recompensed in the same way. And they actually won on that. We have yet to see have the final ruling, but they won on that point that they could compare the two. And the last way you can compare jobs for the purposes of an equal pay claim is where your employer has employed an expert. There are expert companies that rate jobs across the organisation, and you will see that in the NHS and universities. They have banded jobs that fall under bands, which experts have decided are of equivalent value. And it's very difficult to challenge that. Well, unless the report hasn't been done very soundly. So that's those are the formalities of being an equal pay claim. How do you prove it? Well, it's really convenient if you see written evidence of it. And I did have one client who was welcoming in a new line manager who moved into his new office, and he asked her to help him clear out the papers of his predecessor. And he handed her a pile from the inbox. And on top of that pile was a very neatly printed out Excel spreadsheet, which set out her salary compared to the salaries of other directors. Now, these directors were doing very similar jobs to her, so they were an easy comparators to use. And she was being paid 30% less than the next. She was paying 50% less than one of them, but 30% less than the closest male comparator. So that was convenient for her. Most people don't have that sort of convenient evidence. So what do you do? In practice, you may find out because you speak to your colleagues. And I'd urge some caution there, because it can be very painful to find out that you're earning a lot less than a colleague, or create difficulties and tensions if you're earning a lot more than a colleague. So you may want to think about those interpersonal repercussions. But most people do have a trusted friend or someone that they wouldn't mind speaking to about their pay, and they should be allowed to do that. The Equality Act protects your right to speak to colleagues about your pay. It shouldn't be hidden. And although many employers do try to say it should be kept confidential, and in practice might treat you as a troublemaker if you do that, employers can't stop you doing that and should not treat you unfavorably because you have discussed it with colleagues. Um, if you don't want to speak to colleagues about what they're earning, you can look at job postings that your employer is making for similar roles as your own to see whether you're earning the same amount as the amount advertised. You can do market research to see what your role should be earning, but that in itself is not determinative of whether the employer is actually treating you unequally and paying you less than a co-worker. You can speak to your manager or HR, and if your company has nothing to hide, they will often volunteer what other people are earning, or at least what people in certain categories of role are earning, so that you can see for yourself. If they don't volunteer it, then you may wonder what they've got to hide. And finally, it's worth considering bonuses, because most companies, organizations, especially in the city, have wisened up to the fact that on paper, they ought to be paying people the same, whether they're men or women. But the difference comes into the so-called discretionary bonus. Now, a bonus is discretionary. An employer doesn't have to pay it. I mean, some bonuses are contractual and they do have to pay it, but often people have discretionary bonuses. But all that means is the employer doesn't need to pay it if they don't want to. But they cannot use their discretion to pay bonuses to one group of people, but not another group, just because they want to pay out the bonuses to men. They feel traditionally that the men will need it to keep their household going, but somehow the women's money is just pocket money. So bonus is something you may want to ask about, because that should be objectively determined according to a formula that applies across the workforce, not one set of rules for the male workers and another set for the female. That's equal pay then. Now, let's get on to protected characteristics. I didn't really want to bring this term up at all, because it's a sort of, it's an annoying phrase. It's a very legalistic, formal one. But the concept is really important, because our equality laws protect you against discrimination. They don't protect you against any form of unfairness. Now, while all discrimination is unfair, not all forms of unfairness will amount to discrimination. Under the Equality Act, discrimination and harassment, as well as a form of discrimination, depend on either you falling into a protected characteristic, and they're listed out here, or being related to a protected characteristic. So they might relate to someone else's protected characteristic, but it has a harassing or discriminatory effect on you. Now, I'll just quickly go through the protected characteristics that I put up here. Age is one. You may be discriminated against because you're considered too old, or maybe too young. Disability is another one. If you have a disability, you should report it to your employer, and an employer will bring various rights to bear and obligations on the employer. Gender reassignment, there's the characteristic of being married or in a civil partnership. Pregnancy and maternity, it's its own protected characteristic, and slightly different rules apply to discrimination on that basis. Race is a protected characteristic, and that is defined quite broadly or narrowly. It includes nationality, it can include just an ethnic denomination, whatever would define a particular group of people. Religion and belief is another one. Sex, gender is the one I've been talking about so far, mainly in this talk, because equal pay relates to equal pay between men and women. But for the discrimination and harassment, what I say is roughly applies to all of these protected characteristics, even though there are slight differences in how you prove discrimination depending on which characteristic you're relying on. And then finally, there's sexual orientation. Right, let's take harassment first then. Harassment occurs, and this is drawn from the Equality Act, Section 26. It's not verbatim, but it essentially occurs where an individual engages in unwanted conduct towards you related to a relevant protected characteristic. And the conduct has the purpose or effect of violating the other's dignity or creating an intimidating, hostile, degrading, offensive, or humiliating environment. Now, I've underlined some of these points because they're worth considering a bit more. The unwanted conduct is important because it rules out potentially inappropriate behavior that you nevertheless participate in or don't mind. I think we've often been in occasions where a colleague says something which is sort of inappropriate, but everyone laughs along, and in that occasion, perhaps are not offended by it. That wouldn't be harassment. It's got to have the purpose or effect of violating your dignity or creating a hostile workplace. And it has to be related to a protected characteristic. So it may not necessarily be your protected characteristic. I had one client who would fall into, I suppose, a bystander category. He worked on a trade floor and was present when there was continual misogynist commentary about female colleagues, female clients, even the female presenters on the sort of constant broadcast that they had, the TV screens. And he found this really oppressive. And yet, at first, he didn't want to say anything. There was great peer pressure to sort of laugh along. His boss was making as many comments as everyone else. So he didn't particularly want to stand up for what is right, stand up for women and call out this misogynistic behavior, until it became so unbearable for him that eventually he did. And I think this anecdote comes from maybe 6-7 years ago. I think nowadays bystanders are much more ready to stand up. So this is something that will become more and more common. Having stood up to it, he was harassed, even though he didn't stand up for it. But also when he stood up for it, he was then ostracized, subjected to derision and snide comments, and that was further harassment. And he brought a claim for harassment based on sex, even though he was not a woman, but it was based on the way they were treating women and how bad that made him feel. And then let's talk about the conduct having the purpose and effect of violating your dignity. That's really important because it means that you can bring a claim for harassment if your harasser is doing it deliberately. So he wants it to have the purpose of violating your dignity. And that's sometimes the case. But sometimes you have the oblivious harasser, the one who just thinks he's being very cool and funny and completely unaware and insensitive to the effect that his misogyny or racism is having on other people and on the workplace generally. And you can bring a claim regardless of whether it was deliberate harassment or not. But what is important, if you're bringing a claim because it's having an effect of humiliating you, is that you have to have genuinely and subjectively felt that humiliation. It's not enough that the conduct was objectively bad and inappropriate. It has to have that subjective effect. But the subjective effect is also not enough because it does have to be also objectively inappropriate conduct that a reasonable person would think would violate their dignity. So that's harassment. And that's harassment based on a protected characteristic. And the characteristic may be gender, it may be race, it may be age, it may be any of those other listed protected characteristics that we discussed before. Sexual harassment is the same as harassment, except the unwanted conduct is of a sexual nature. But otherwise, it's roughly the same. It still has to have either the purpose or the effect of violating your dignity. And it's worth noting that for both harassment and sexual harassment, you also have a claim if you're unfavorably treated after rejecting or submitting to the harassment. This often comes up in sexual harassment, and it's applicable whether someone rejects a sexual advance from, say, their boss, or submits to it. Either way, they may then get unfavorable treatment afterwards, and then they would most likely have a claim for sexual harassment. Moving on then to discrimination, and this is almost the sort of meat of it, the meat of the Equality Act. there are two forms of discrimination. I think the most obvious one that we all think about is direct discrimination. And this is where, because of a protected characteristic, that's how the Act describes it, that your employer, a boss, a colleague, treats you less favorably than others. For direct discrimination, you have to have a comparator, rather like equal pay. Because it's defined as being less favorable treatment, you have to show that someone who is similar to you in most respects, except for your protected characteristic, has not been subjected to that unfavorable treatment. Now, it's not always easy to find an actual comparator for your discrimination. There may simply be no one else who is in the same role as you or a similar role as you to compare yourself with. In that case, you can call upon a hypothetical comparator, but it's slightly more difficult to prove, and you would have to prove it by looking at trends within the organization suggesting that there's a discriminatory motive to your less favorable treatment. And it's worth noting also that there are some forms of discrimination which are like direct discrimination, but not quite like that, because you don't have to find a comparator. And I'm thinking particularly of pregnancy and maternity discrimination. There, it's just important that you show that you are being treated unfavorably during the protected period of your pregnancy and maternity leave. And also for discrimination arising from disability, you also don't need to find a comparator. But for most forms of direct discrimination, you do need to think about who are you going to compare yourself with? It's got to be someone in a similar role, but who is treated differently and in fact better than you. Indirect discrimination is slightly more complex to prove, but it's the sort of discrimination that happens when an employer has one rule. In the Act, it's called a provision, criterion, or practice, but it's essentially a policy that they impose across the workforce or across your team. So it's sort of regardless of gender or race or any protected characteristics. On the face of it, it looks as if it's fair, it's not discriminatory. But in fact, it has a particular impact and disadvantage on a particular group of people who have a protected characteristic. And it may be best demonstrated through an example. For instance, if your employer decides, let's have the team meeting at 6:30 in the evening. While this is a rule that applies to the entire team, you're all expected to be there. It's clearly going to have put at particular disadvantage people who are either on a part-time contract, so they wouldn't normally be working at 6:30, so therefore they either have to work outside their contractual hours or simply miss the meeting, which will do a long-term detriment to their career, or people who may be working full-time but nevertheless have young children, for whom 6:30 p.m. is about the worst time in the day you can schedule a meeting, and so they are either going to be distracted on the call or they're just not going to be able to be there. And that sort of policy would be open to challenge as being indirectly discriminatory. For indirect discrimination, an employer can say, well, it's objectively justified. And in the example I gave, I suppose they might say, well, this is a meeting that directly relates to a 7 p.m. broadcast, and it's a news, it's sort of current events, and so it has to be just before the broadcast. That would be an objective justification to explain why the meeting has to be then. But if there's no objective justification, then it seems to me like a discriminatory policy. Right. What to do then? Let's give some practical suggestions. If you suspect that you're being subjected to unlawful harassment and discrimination. For discrimination, as I discussed, you want to start thinking about your comparators, comparing yourself with other people otherwise similar to you, but with a different not with your protected characteristic. Whether you are perhaps comparing yourself with a white colleague or with a male colleague or someone older or younger. You can speak to your colleagues. Now, again, I urge caution. It very much depends on what relationships you have with your colleagues, but it can be really, really helpful to to test out what you're experiencing with other people. For a start, it will help you overcome the notion that it's all because of you. The thing I discussed at the beginning of this talk, that it can be almost the most damaging thing to internalize that treatment and think that it's all you're overthinking it, you're being oversensitive. If you speak to someone else and they have noticed your harassment, and the chances are they will have done, then that reaffirms you or vindicates you in your own experiences. Now, beyond that, they may be useful as a corroborator or witness to what's happened. So if you decide that you want to go to HR and make a grievance, then it is really useful to be able to say who might be able to speak to that too. You're always going to be stronger if it's not just your word against the organization. If you have 1, 2, 3, as many supporters as you can get, and not just people who support you because they like you, but people who support you because they've witnessed the conduct and they think that it's wrong, they think it's harassing or discriminatory. And also, you may find people who have been discriminated or harassed themselves in different ways. So in that circumstance, you may not be direct witnesses for what you've each suffered. And this often comes up in sexual harassment, because sexual harassers will often be smart enough not to make their overtures or passes overtly, but in a one-on-one situation. So it's unlikely, often it's unlikely to find a direct witness to a particular sexually harassing event. But what you might find when you speak to other people is that that other person has also been sexually harassed by the same person. Or there are other things that they've experienced that corroborate generally what's happened to you. So those forms of corroboration are also really important, both if you're bringing a grievance or if you take that extra step and go to court. Another thing I haven't written up here, but is really important to do, especially if you are experiencing the sort of death by 1,000 wounds, hopefully not death, but discrimination and harassment by 1,000 wounds, keep a timeline. You will not remember all the incidents that have happened to you. They will merge into one. And often the incidents will occur over a year or 2 years. And it's really important to keep a timeline. If it's related to emails you've received, I would keep a timeline and a dossier. Print out that email, keep it. You may end up with a whole book and a whole massive file of papers, or maybe screenshots, depending on how you want to keep it. And that will help you if you want to bring a grievance. You don't want to be turned away because people don't believe you. If you have evidence, either other people or documentary evidence, or just your timeline, which is so specific, it's hard to believe you've made it up, then that's going to really help you out. And then, yes, once you have got all these things, once you've done 1, 2, and 3, then I would go to your manager. It takes some courage. It's far easier for me to say it than for you to do it. But certainly give me a call if you want some encouragement or just to sound out whether you've got reason to go to your manager. But it is really good to put in a grievance, because a good employer will want to learn from that. They may want to change things. They may address it. They may train the person who's harassing you. And it's important also to make a complaint because of this victimization. This is the last key protection that I'm going to talk about under the Equality Act. Victimization is a protection that you get against retaliation. It's really another formal term for retaliation. You are victimized if you're subjected to a detriment, so any unfavorable treatment, because you have engaged in a protected activity, or your employer thinks that you may engage in one. So perhaps you haven't done anything, but your employer may be nervous that you are suspecting harassment and are going to do something. The protected acts, I've actually put the definition down here. It's quite broad. It's either bringing proceedings under the Equality Act, but it need not be anything as definitive as that. It may be making a grievance. It may be giving evidence or information in relation to someone else's grievance. It may be just making an allegation, or doing anything in connection with trying to seek to have your Equality Act rights implemented or adhered to. from a lawyer's perspective, a victimisation claim can be much simpler to bring than the underlying discrimination or harassment, which may be more nuanced. You may not have that wonderful timeline and dossier of evidence, even though it happened. It's much easier to prove that you've made a grievance and then that you've suffered a detriment because of it. So that's the reason why lawyers are quite keen for you to put in grievances, because it preserves your rights more fundamentally going forward, if you want to go to the employment tribunal, but also at work. So stress at work, it's a claim that works whether for instance, if you're being bullied, but it's not in relation to a protected characteristic. For example, say all the people at your level are being bullied by the same boss, then you may yet have a claim, even though it won't be under the Equality Act, but you may have a stress at work claim, and you would if it had caused a psychiatric condition because of unreasonable conduct. So you are expected to have a certain amount of resilience to put up with the normal strains and tensions of office life. But if you're being subjected to unreasonable conduct, you have to be on 24/7 call, or you have to sort of randomly be called at the weekend to give up whatever you're doing to do a sudden urgent thing, even though there's no real external urgency to it. Then it may cause very real psychiatric stress. And what I would urge you there to note is, do put your employer on notice. Don't be brave and put up with it. A lot of people who suffer stress, say depression and anxiety because of work, also suffer physical symptoms associated with that. And when they put in their sick note, they're careful to only mention the physical symptoms, not the stress at work. And they ask their GP to do that. And that's not a good idea, or it doesn't protect you as well. You really need your employer on notice of the stress at work so that they can then speak to you about what accommodations to give to you, what adjustments to make to relieve you of that unreasonable conduct by someone else or the unreasonable pressures you're being put under. Stress at work claim has to be brought within 3 years of suffering the injury. So you have a bit longer also to think about it. And then there's the Protection from Harassment Act. This is an act that doesn't apply to discrimination as such, but it does apply to harassment. And it requires 2 incidents, and they must be done with intent to cause distress. So unlike the Equality Act, you do need it to be deliberate. And each incident has to be quite serious. It has to be so serious that it is prosecutable as a crime. Now, that's not a very helpful definition, because it actually doesn't have to be prosecutable as an assault or a battery or as any particular criminal offence, because the Protection from Harassment Act itself can be a criminal, it can be prosecuted as a crime, as well as giving you a civil right. But generally, a good rule of thumb is to think about whether there's the threat of physical violence, either physical touching or the threat of it would be enough. And each incident has to be that serious. So in one case I had, there was a person who was subjected to sort of long-term bullying. And one of the incidents we relied on was when they gave their boss a report they'd been working on, and the boss screwed it up into a little paper ball and chucked it at them. That was serious enough, because it sort of went beyond just the normal sort of tensions you might expect in the workplace. Finally then, just to sum it up, the practical guidance. What should you do if you think you're being harassed, discriminated against, or just poorly treated? Write it down, keep a log, keep a timeline, maybe take screenshots of evidence. Speak to other people cautiously, but that can help both to give you support and strength, which is good for your mental health, but also corroboration. Call it out, and by that I mean go to HR, make a grievance. You might want to give your boss a chance to do the right thing, even if you suspect that they won't. But if you do go to HR and they then don't do the right thing, then you may have a victimisation claim as well, and protections that arise from that, on top of your original protections. And then finally, remember those employment tribunal time limits. They are ridiculously short. It means you have to bring a discrimination claim in, I would say, an unreasonably short amount of time, much shorter than if you have a car accident and you bring that claim. So there is a lot of lobbying going on to try to make those time limits a bit more reasonable and in line with the rest of the law. But that's what we have to deal with today. So that concludes my slides and the formal part of this webinar, but now the more interesting bit is your Q&As, and I'll look both there and the chat. So perhaps, gosh, I'll go to the chat. There's one from Runa. I'll read this out. Is there a timeline for this? As I was a union member and did not get help, and I seemed legal advice that said my rights were limited because I had only worked there less than 2 years. What do you advise? That's a really great question. I didn't touch on that. People are often told that they only have employment rights if they have been employed somewhere for 2 years. Now, that is true of most of the rights under the Employment Rights Act, the unfair dismissal. You can only claim those rights if you've been there for 2 years. However, discrimination kicks in from the word go. From the moment you apply for a job, you have a right not to be discriminated as an applicant. So you may never get the job and you still have a right to bring discrimination claim. And from day one on the job, if you're discriminated against, you have a right to bring a claim. So that hopefully answers that first question, Runa. And you also go on to ask, how do you log evidence about sexual harassment if there's no written evidence or witnesses? How do you prove it? Again, a really good question. Not all sexual harassment has convenient WhatsApp messages inviting you to come over that night. Sometimes they do. So, I mean, those things, I would tell you, please keep, even if they disgust you, it is good to keep those, keep screenshots, or at least keep a screenshot printed out maybe, rather than just deleting it, because it can be useful. Sexual harassment where there are no witnesses, that's often the case. Then I'm always very keen to speak to other people who might have also been sexually harassed, because although they haven't witnessed your sexual harassment, there may be repeat sort of recidivist behavior. That's often one harasser often harasses more than one person. So if they've harassed you, the chances are they've probably harassed other people in the organization. So that sort of like conduct evidence is really useful, and it's really the main evidence that you can rely on. So I hope that answers that question. Right, going over to the Q&A. Where does intent play into all this, if at all? Well, it depends what claim you're bringing. For the Equality Act, for harassment, there doesn't need to be intent by the harasser. It just has to have the effect of harassing you. And so that can be sort of quite, it takes away that difficulty in proof. For discrimination, there has to be the exact wording is, you've been subjected to less favorable treatment because of a protected characteristic. So there has to be a connection between the unfavorable treatment and your protected characteristic. Sometimes the Employment Tribunal has said, well, consider whether but for your protected characteristic, would it have happened? That's a useful way of considering it, but it's not always determinative, because sometimes something would have happened. You would not have had the protected, you would not have had the unfavorable treatment, but for being, say, pregnant and on maternity leave. But that still doesn't, there was another reason why it happened that doesn't relate. It wasn't because of your protected characteristic. Sorry, that was a garbled response. Let me give you a clear-cut explanation of what I'm trying to say, because it comes from a specific case. So, for instance, there was someone who was out on maternity leave, and their employer were advertising a job that would have been a promotion that she would have been right for, she could have applied for, would have applied for had she been at work. Now, the employer notified someone else who was also on maternity leave of this opportunity, and that person did apply for the promotional job. But the employer just forgot to send notice to the claimant, who was also on maternity leave, about the opportunity, and so she didn't apply for it, she didn't get it, and that was unfavorable treatment while she was on maternity leave. But the court said that in this case, although applying the but-for test would mean, well, but for the maternity leave, she would not have had that unfavourable treatment because she would have been at work and she therefore would have seen the job opportunity and been able to apply for it. In that situation, the but-for test was not enough because you do need to go one step further and say, but is there, was the reason because she was on maternity leave that she didn't see it? And the court had well held that that was not the case, that in that situation, the employer's reason for not sending it was administrative error. They had sent it to someone else on maternity leave. So that was a fairly long response, but I hope that makes sense. Intent plays some part in discrimination, but it does not play a part in harassment. And intent does play a part in the Protection from Harassment Act claim. So I hope that answered that question, Tiara. And now I have another question here. What if there's no one in the same role as me, and so I cannot tell if I'm being treated less favourably? Well, that does happen sometimes, as I think I may have mentioned on, but only quickly in passing. For a discrimination claim, you need to be able to persuade a tribunal that you're being treated less favourably than someone who does not have your protected characteristic. But it's recognised that there may not always be anyone in that role, but you still think that you're being paid less, either paid less favourably or treated less favourably than someone else. And in that situation, you call upon this sort of notion of a hypothetical comparator. You're trying to prove to the employment tribunal that had there been a man in this role, he would have been treated more favourably than you're being treated. And you can prove that by looking at, say, a predecessor in role who may have been a man, and maybe he was had much favourable terms or was given opportunities that you weren't given as a woman. Or it may be that you can look across the board at the organisation and show that across the board, male colleagues in different roles, sure, but nevertheless, male colleagues are being given opportunities that female colleagues are not. So there you're looking at it on a more macro basis. So I hope that answers that question. And I think that concludes the questions. Let me just check the chat again. Yeah, I think that's everything. So I'm going to round this up now. Thank you all for your patience. I'm so sorry about the technical hitch, but gosh, heck, it wouldn't seem live if we didn't have that. It's been a real pleasure speaking to you all, and I wish you all really the very best and good luck, and shape that workplace to suit yourself. Don't put up with discriminatory treatment. Thank you. Bye-bye.